Hey there, everybody. Lance Fryrear here from the law office of Lance Fryrear, and this is a quick uh, Facebook live event where we're going to try to go over restraining orders and what are some do's and don'ts for responding to restraining orders in Washington State. And if there's any questions about obtaining a restraining order, I can also cover that as well. So, number one, what is a restraining order? A restraining order is a type of civil action that one person can file against another person, where the petitioner, that's the person filing the restraining order asking for help from the court, um, files their reasons why they want the respondent, the person that the petitioner is mad at, to not have any contact with them or to be thrown out of the house, or to stay away from them. And there are different types of restraining orders out there. There's a harassment restraining order, and that's basically saying, hey, the respondent has had contact with me which intentionally caused me emotional distress. They made me afraid, they made me embarrassed, could be harassing text messages or threats, all sort of a catch all. So that's an anti harassment order. There's also a domestic violence protection order that would be for a family or household member, someone you've dated, someone that you've been involved with or lived with even without dating. So that says where I'm a victim of domestic violence, and therefore, court, I want you to order the respondent to not come to my home. If we live together, to be thrown out of my home, to not have any contact with me, possibly not to see the kids if you have kids, things like that. So those are the two most common forms of restraining orders. There's a stalking restraining order that you can also get if someone's following you and isn't leaving you alone, is scaring you by following you or maintaining, um, wear tabs on your whereabouts, that type of thing. So, and finally, there's another type of order called a sexual assault protection order. A sexual assault protection order is more serious in that type of situation. You're saying, hey, I'm a victim of a sexual assault, and I want the respondent who did this to me to not be able to contact me anymore. So, those are the types of orders that a person can try to get or a person could need to respond to. And so the main focus of this broadcast is, what are some tips for responding to restraining orders? So again, how does it work? The petitioner goes in and asks for an order. The court will grant typically the petitioner a temporary protection order, which is good for 2 weeks. And that's without notice to you as a respondent. And then you get served by the police. You get served with the temporary order says, hey, you can't have any contact with the petitioner, and hey, you might need to leave the home if you live there, stuff like that. But then there's a court date. So you'd want to take a look at that petition, and on the top, take a look at the court date. And so you know when it is you as the respondent needs to go to court to have your chance to answer what happened. Because when you get that temporary order and petition served on you, you need to look at it, see what the court date is, and then take a look and see what the petitioner wrote. What is it they're claiming that you did, which you're probably not going to agree with, right? What are they claiming that you did that gave them a temporary protection order against you? And a common mistake is we think as a respondent, hey, I'm just going to go to the court date. Usually the court date's within about a week after you get served, maximum 2 weeks. I'm just going to go to the court date and say my side of the story. I'm just going to say what happened. And while that's a good idea, it's typically a mistake to not file a written response, because how it works is the court, example in Snohomish County in Superior Court, they've got a 1:00 hearing every single day, and they're going to need to get that over with at some point. So at that 1:00 hearing, they might have 20 or 25, hearings that day. So they don't have time to take testimony. They don't have time to hear your side of the story right then. Basically, what you're going to need to do is file a written response ahead of time. And how do you file a written response ahead of time? What does that mean, Lance? Well, what it means is you need to get the declaration form off the website, or you can get a hold of an attorney. We can help you with it as well. You get a declaration form, and you need to basically fill out a sworn statement. I declare under penalty of perjury that the following is true and correct. And for those of you just joining us, basically, I'm going over how we respond to a restraining order in Washington State. What are some tips for that? And so the first tip, don't just show up and explain it. You need to file a written response. And again, to file the written response, we get a declaration. We write out our version of what happened, what's true and what's not true about what the petitioner claims. And then we need to go ahead and prior to the court date, typically 2 days prior, sometimes longer, you need to file that written response with the court because the court needs a chance to read it, right? If you just bring it with you to court, the court's not going to have time to read it. If you file it the same day as court, guarantee you the court's going to have no time to read it. And certain courts have a certain time frame where you need to file that response. As far as what else you need to do with the response is you need to have someone, not you, someone file that response on the petitioner, because just like you got the petitioner's paperwork prior to the court hearing with the petitioner's claims, the petitioner needs to have your response prior to the court hearing. And the rules say that anyone over 18 can file it, or serve it on the petitioner, but you're not allowed to do that personally yourself because that would probably violate the temporary restraining order and get you arrested. So definitely do not do it yourself. So do I have to go to the hearing? Lance, do I have to go to the full order hearing to fight about this? Well, because it's not a criminal matter, you're not required to appear. If you say, hey, I don't care about the order, it's too stressful, I don't care if they have an order against me, you can just not show up. So the upside of that is you don't have to worry about it. The downside is that the petitioner is going to get his or her order against you with terms you may not like. The typical time frame for an order against somebody is 1 year. But if you don't show up, sometimes they might get it for more than 1 year. So basically, that's what will happen if you don't show up. And if anyone has any questions, make sure you type them in. And I've got a person here in the office helping me, and we'll hopefully point it out because this is the first time I've done a Facebook Live. So what are some other tips about the response? What should be in the response, Lance, and what shouldn't be in the response? Well, what should not make your response is anything that could be a crime. Okay, let's say you're being accused of a domestic violence protection order where you're accused of assaulting somebody. Well, you wouldn't want to write in there, well, he says that I hit him, but all I really did was push him. Well, you just admitted to a crime. Potentially, if you say you admit to pushing someone, that's a sworn statement. The police can get it. A prosecutor could get it. So you want to make sure to avoid doing things like that, admitting to any crimes. Well, what should go in it, Lance? Well, basically, you need to tell the true emotional story of your interactions, your relationship, your life with this person who's the petitioner who's trying to get an order against you. The person who's going to decide whether or not there's a 1 year or longer order against you is a judge or a commissioner, and that's a person, and they typically decide on emotion. Simply saying, I did not do it, is likely not going to be very persuasive for the judge, because the judge is looking at the petitioner who's upset and they're scared, they may be crying. Instinctively, the judge wants to grant the order because it's just a civil order. So the really best chance you have to win is to tell that story that's true in an emotional way so the judge, who's a human, can identify with what you've been through. So, instead of saying, no, I didn't do it, you'd say, well, this is what happened in my life. I've lived with this person for the last 6 months, and they've been mean to me. They've yelled at me about the dishes or the cat or the dog or whatever. You need to get it out there and how it made you feel. It cannot be just the facts for you to have the best chance to win. You've got to hit an emotional response. And don't forget about exhibits. Text messages, you can take screenshots and file those ahead of time. You can get witnesses to file declarations as well. You can get a witness to go ahead and write out their own declaration about what they saw. Again, they're not going to probably have a chance to testify in court, but if you have somebody that you want to testify for you at a restraining order hearing, you need typically to have them file a sworn declaration ahead of time. And you can get those sworn declaration, the paperwork, you can get them on usually the website of the court, or you can contact an attorney. You can retain an attorney. We do this type of work. We do full defense, and we actually have a coaching program too, where we help you coach through it. It's a lot less costly. But what we want you to do is make sure that response tells an emotionally true story. Well, Lance, how do I figure that out? We tell our clients to write out to themselves and then give to us a story that we call a once upon a time story. If you start the written version of the events when you're getting your first draft down with once upon a time, it basically activates the storytelling part of the brain, and it comes out different. It comes out more than just the facts. So regarding restraining orders, you might want to know what happens at the court hearing. Well, the court hearing, a good number of them are by Zoom, some are in person, so pay attention, try to figure that out ahead of time. But at the court hearing, the petitioner's got to get to say his or her side of things, and then the respondent, you, in this case, if you're the one responding, will get to say your side of things, but mainly it's done just on the reports. Imagine that the petitioner may have like 2 minutes, 3 minutes to add something, and you might have a few minutes to respond to that. And then the judge will just make a decision. If you haven't had time to file a response, or you're trying to get an attorney, make sure that you tell the court that before the hearing starts. The courts are fairly liberal in granting a 2-week continuance because it's a very short period of time. And also, the court needs to get moved through the calendar. So if you have a good reason, oftentimes you can get more time. A question that we often get is, Lance, what are the consequences of an order being issued against me? Does it go on my record? Well, it's not a criminal matter. It doesn't really involve the government. It involves a court, but it does not involve a prosecutor or anyone bringing an action against you. It's Mr. or Mrs. Petitioner versus Mr. or Mrs. Respondent, right? So it doesn't really count for your criminal record. It could still be, it could be seen if people know where to search and people can know that this civil matter exists. But in our experience, and I've been doing this for 27 years, we haven't seen it cause problems for employment unless you happen to work at the same place as the petitioner. Then it could be a problem. Then you might not be able to keep your job if the order is granted, because you could be violating the order by being there. So what are the main points? 1, you have to file a written response. 2, somebody besides you has to serve it on the petitioner. 3, we have to file the written response with the court, usually at least 2 days ahead of time to be safe. 4, we cannot and should not talk about crimes in the written response. And 5, we need to do more than just the facts. We need to reach the emotion. So if this sounds like it's too much for you, many people will go try to get some attorney help. If you happen to be in this situation, you can always give our office a call. Again, my name's Lance Fryrear. We're located in Lynnwood, Washington. You can reach out to us on Facebook. We have a whole bunch of videos about restraining orders and how to respond to them on our YouTube channel. You can also get an ebook that we have for free if you go to www.restrainingorderplaybook.com. You can download an ebook with some tips. We want to try to make it so you have a chance to do it yourself. And like I said, we do full defense, and we also have a coaching program to make it more affordable. So I hope this has been helpful, and feel free to reach out to our firm at any time, and we'll see if we're able to help. Have a great day.